Excellencies, ladies and gentlemen, thank you very much indeed for giving us this opportunity to speak before you. The issue that I wish to consider today is the legitimate expectations of foreign investors. Professor Hebié has already spoken about the criteria, the idea of fair and just treatment. Judge Youssef also explained how behaviour or actions that are apparently unoffensive have been used by international tribunals to very powerfully impose, force host states to issue reparations and damages. My view is a little different. It's a little different because I'm not trying to change the content of standards in this domain. Standards exist. They exist in many bilateral investment treaties. There are attempts and expectations that these standards will be changed, but to date, none of these attempts have proved fruitful. So what I'm endeavouring to do here is to look at the sort of framework of these standards and what can we draw from them to avoid being held responsible for any negative consequences of their foundations or the application of their rationale. Investment tribunals believed that foreign investors had expectations that they labelled as legitimate. The first of these expectations, when foreign investors go to a country and attempt to negotiate a contract, well, the first expectation they harbour is that contractual clauses will be respected. That's not particularly complex. We all understand the need for someone to remain true to their word. But the second expectation is perhaps a little more sensitive. That is that tribunals have considered that promises, guarantees, be they formal or informal, that the host state might have given either voluntarily or involuntarily, well, they believe that these guarantees and promises were also legitimate. And there are problems that arise here because tribunals are not looking to know whether the host state wished to meet these legitimate expectations or give them it. They're not looking to examine whether the expectations that they believe were legitimate have been given in line with international law. So perhaps an agent might have given rise to expectations that he didn't really have the authority to give rise to, and that's examined by tribunals. Tribunals don't only look at actions, they also look at omissions. So that you have expectations, legitimate expectations, but given that you're now looking also at omissions, all of these expectations give rise to quite tangible issues of liability, particularly when you haven't really been able to properly examine clauses pertaining to expropriation, for example. Now, the other thing that tribunals consider, well, what they try and do, as Judge Youssef said, is to read a stabilization clause into contracts that didn't have it. So it's considered that in foreign investment legitimately expected that the legal framework that they found when they made their investment remain in place during almost all of the duration of the investment, and that gives rise to LDCs and developing nations. That is, well, it's quite logical that in those countries the legal framework changes. That's quite common. It's normal that we consider human rights, the right of workers, they're beginning to be considered, as are the rights of the environment, etc., etc. And so under this idea of legitimate expectations, well, investment tribunals sanction two forms of behaviour on the part of host states. Now, the first, there are three, but I'll focus on two. The first type of conduct is that they've punished is cacophony in the various statements made by various bodies. A state body can say that an investment doesn't require a permit. Another body says that environmental law does need to be respected. So there's cacophony or confusion, if you like. People are issuing different standards, and that falls short of the legitimate expectations of investors. Now, the other source of liability that was considered is a lack of consistency on the part of state leaders. You might have a first government that was very open to investors, that fosters FDI, he can come to the table, give you tax relief, etc., tax cuts, but then you'll have a second government perhaps, and that government would say, well, no, that's not actually how I'm going to operate. So there's inconsistency in terms of the action undertaken by various governments that succeed each other, and that can undermine and disappoint legitimate expectations of foreign investors, and that's being looked at by investment tribunals. Now, sometimes when decisions are taken by investors, they don't always take account of the level of development of the country where they make their investments. Sometimes they note that there's a climate of political stability or instability. They look perhaps at the fact that states are moving towards a market economy after having a planned economy, but often the real kind of timeline that a state has followed is not really taken into account when establishing legitimate expectations, or whether certain expectations are legitimate or not, or whether they have been disappointed or not. So states, what can we do? Well, states have decided to try to change standards. And so states tried to change the standards, and that didn't always work. Now, I tried to pioneer 3 approaches, and I've issued 3 recommendations. Now, my first recommendation is largely psychological in nature. Host states, including host states on the part of in the LDCs category, they can't simply limit the interpretation of contracts to the provisions themselves in the strict sense of the term. Negotiating contracts is broader, and then you need to look at all communications that you've had with investors, not only the contract itself, if you're evaluating whether or not legitimate expectations have been fulfilled. Communication needs to be fully fleshed out. There needs to be an organization, which means that 30 years following an investment, when a dispute arises, well, that you can trace back, you can look back at what a host state communicated to its investors during the investment period. We can't simply look at the contract itself. Now, to avoid confusion and inconsistency, institutional measures need to be taken, and this is my second recommendation. Now, the measures I'm proposing here is to establish investment facilitation and promotion centres, which would allow foreign investors to be properly dealt with and have their expectations met. This would be a centre which would allow investors to enter into contact with state bodies, and this would be the only body there where they could do that, and where the state could communicate their needs to foreign investors. So that having these kind of centres would act as a sort of channel for communication and ensure that the rules of the game are clearly established. Now, the third proposal that I would make is that, well, we need to look at the issue of the negotiation of foreign investors as a matter of expertise. Expertise is important to take into account. What often happens is presidents and prime ministers come to the table and they say, well, everything's fine. We don't need environmental standards. They say that, but when they take those decisions, they haven't properly taken account of their domestic legal framework. So we need to really have recourse to experts, allow experts to study the general panorama and issue one unequivocal, firm position regarding standards that foreign investors must follow. That doesn't mean that you need to put an end to economic diplomacy. You can continue to undertake efforts of economic diplomacy, but having this reliance on expertise will stop proposals from being vague and stop having an absence of promises made to investors, or stop expectations or promises not being fulfilled. Now, the expectations of a foreign investor must be deemed as things that can give rise to disputes. And here's an important area of capacity building. Domestically, there needs to be state agents that are able to examine communications and say, well, there, a problem could arise regarding expectations. And that means that we need to take measures which stop problems of liability and disputes arising. Now, my last point would be relating to the contract itself. A foreign investor cannot say he's got legitimate expectations and look to enforce those and bring them to court if they're excluded from the contract. It's very important, therefore, that when you draft a contract, therefore, you can look at expectations that you can't create and therefore remove them from contracts, and what are expectations that can be fueled, and therefore how can they be incorporated into the contract? I know I've already run out of speaking time, so thank you very much for your attention.